My name is Howard Takushi, and I want to welcome you folks to the Fordham Law and Psychology Seminar. Today we're delighted to have some distinguished guests. But before I introduce them, I want to introduce Bridget Amatore, who is an officer with the New York State Forensic Division, Psychology Division, and she'll say a word about her organization. Dr. Amatore.
Well, it's good to have the band back together again. Thank you, Dr. Takushin, Mr. Deskovic, and Dr. Sorochinski. I'm Dr. Bridget Cory, and you are not alone from John Jay. I'm a professor at John Jay, and so, of course, we're down the street and we're neighbors. I'm the treasurer of the Forensic Division of the New York State Psychological Association, and I want to welcome you as a co-sponsor of today's presentation. Mr. Deskovic has been my guest speaker at John Jay on a number of occasions, and he's quite captivating and has a very compelling story. The New York State Psychological Association welcomes student members. Applications for you in case you would like to join. It's $35 for a year, and every division membership is free. In the Forensic Division, we work very hard to meet your needs, to meet the needs of all our members, and to do workshops and seminars that span the array of forensic issues, from criminal to litigation to civil to adjudication, anything that you're interested in, including child custody and immigration. So I want to thank you, and I want to welcome you on behalf of the Forensic Division. I have applications, we can meet later, and I have a sign-up sheet. If you have any questions about the division or NISPA, please sign up, and I will get back to you and contact you, and we can talk. And now, let's begin the program. Thank you so much.
Thank you. Is the sign-up sheet one that you want to pass around now?
Yeah, if they want to.
Yes, by all means, that's a great idea. Some may be considering a career in psychology and law. How many of you are thinking of that? Would you raise your hands? I see about 4 hands go up out of about 25 of us. Thank you. Those of you studying law and psychology know that this country, more than any other, has tried to ensure a fair legal system, right from 1789, the Bill of Rights. And yet we know that mistakes are made. We know from the Innocence Project and other organizations that people can be wrongfully convicted. And today it's a pleasure to introduce a team of folks headed by Jeffrey Deskovic. Mr. Deskovic spent something like 16 years in behind bars for a crime he obviously didn't commit, and fortunately he was exonerated. And he is really a champion, well known around the country for his efforts to reduce wrongful convictions of other people with his Deskovic Foundation. He's accompanied by a few leading scholars, Marina Sokolovich from Sorochinski, from St. John's University, and Cory Morris, who's a private practice social justice attorney in Long Island. And he'll introduce another person or two that are with his team. And he'll share with us today about wrongful convictions and how we can adjust the procedure to overcome this problem. And of course, Mr. Deskovic is not only generous with his time, but he earned a law degree. So now he's an attorney here in New York State. I should note that it's about a little past 1 p.m. now, and we do have to end the session at 2:15 because of the room size. So I'll turn it over to Mr. Deskovic now. Thank you for joining us.
Good afternoon.
Good afternoon.
Good afternoon.
Good afternoon.
All right, listen, we're free. We can start with that, and we're here at a educational event, so it's all that's really nice to do that. So as Dr. Takushian alluded to, I did spend 16 years in prison for a murder and rape, which I did not commit here in New York. My wrongful conviction, which happened in 1990 in Westchester County, was for a murder and rape, which I did not commit. The conviction, which happened despite a pretrial negative DNA test result, was caused by a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, terrible public defender. Let me unpack that a little bit. So in terms of the coerced false confession, false confessions have caused wrongful convictions in 25% of the DNA-proven wrongful convictions. And while adults have been known to falsely confess, particularly vulnerable groups are youth and people with mental health issues. So to give a super tight overview on my case, and then I'm going to jump to the policy portion of my presentation this afternoon, rather. So the setting was 1990. It was Westchester County, New York, Peekskill specifically. There was a population of approximately 25,000 people, so murders were pretty rare. When this murder happened, it created an atmosphere of fear, rumor, paranoia. Parents were concerned with their own safety as well as the safety of their children. In high school, I was quiet to myself. I didn't participate in a lot of organized sports, and this made me seem strange to the kids in the high school. The Peekskill police interviewed a lot of students from the school, and some of them told the police they might want to speak with me because I didn't quite fit in, and that was how I got on the police radar. An additional factor was I was a sensitive teenager, and this was my first brush with death, and I had an emotional reaction, and so the police viewed my having an emotional reaction as being suspicious. So a second factor. And lastly, the Peekskill police got a psychological profile from the NYPD, which purported to have the psychological characteristics of the actual perpetrator, and I had the misfortune of matching that. So it was you might say, a confirmatory type of factor. I came from a single-parent household. My father was never involved in my life in any aspect, and that intersected with the good cop, bad cop technique. I began to look up to the officer who was pretending to be my friend as a father figure. Prior to being a teenager, the career I fantasized about having when I grew up was actually to be a cop, and that intersected also with this theme the police developed. So my interactions with the police, the interrogation, it always had the following dynamic of that half the time they would speak to me as if I was a suspect, and when they would push too hard and I'd want to get away from them and I'd become afraid, they would switch it up. And Jeff as this junior detective helper theme was what they pushed. The police won't talk freely around us, but they will around you. Just come in from time to time. They would ask me opinion questions and congratulate me on that my opinion was correct. They made me feel important. Eventually, they got me to agree to take a lie detector test. They said that there was some new information that had come into the police file, and they wanted to share that with me, and that would allow me to be more helpful to them. First, though, I would have to take and pass a lie detector test. And so the next day, rather than report to the high school, I went to the police station where I thought the test was going to happen, having heard that other people were polygraphed there through the rumor mill. But instead, they drove me to the town of Brewster. So it was 40 minutes away, which meant that I was no longer able to leave on my own anymore. I was totally dependent upon the police. They put me in the car with the officer who was pretending to be my friend. The other two officers were in a different car, so the psychological game continued. When I got to Brewster, the polygraphist was a Putnam County Sheriff's investigator, except that he was dressed as a civilian. He never identified himself as law enforcement. He never read me my rights. They gave me a 4-page brochure which explained how the polygraph worked, but it had a lot of big words in it that I didn't understand. But then I figured, well, I'm here to help the police. What does it matter? Let's just get on with it. From there, they gave me countless cups of coffee, which seems pretty clear in hindsight that the purpose of that was to get me nervous. At 16 years old, I was not a coffee drinker. And then they put me in a small room, and then he literally wired me up with the polygraph machine, and then he launched into his third-degree tactic. So he invaded my personal space, he raised his voice at me, he kept asking me the same questions over and over again. And as each hour passed, my fear increased in proportion to the time. He kept that up for 6.5 to 7 hours. Towards the end, he said, "What do you mean you didn't do it? You just told me through the polygraph test result that you did. We just want you to verbally confirm it." And that really shot my fear through the roof. And at that point, the officer who had been pretending to be my friend, he came in the room and told me that the other officers were going to harm me, that he had been holding them off but couldn't do so any longer, that I had to help myself. Then he added that if I just told them what they wanted to hear, that I would not be arrested, that I would be able to go home afterwards. So being young, naive, frightened, 16 years old, not thinking about the long term, I was just concerned with my safety in the moment. I was in fear of my life because the fact that I didn't know where I was and no one else knew where I was either loomed quite large in my mind. I was overwhelmed emotionally and psychologically. Then there was this possibility of harm that he had threw in the air, and then this false promise that I was not going to be arrested. So being young, naive, and frightened, all those things that I already mentioned, I made the decision to falsely confess, incorporating the information they had given me in the course of the interrogation that day and in the 6 weeks run up to that. By the time it was all said and done, I collapsed on the floor in a fetal position, crying uncontrollably. Obviously, I was arrested. I was charged with a murder and rape. DNA test showed that semen found in the victim didn't match me. The prosecutor got the medical examiner to commit fraud and falsely claimed that he remembered that he forgot to document certain medical findings which he claimed showed that the victim had been promiscuous, and that was their explanation for how the DNA didn't match me, and yet I was still guilty. He went so far as to name another youth by name. He never tried to prove that conclusion. He didn't have a DNA test performed. He didn't call that other individual as a witness. He just made the unsupported argument to the jury. My public defender essentially didn't defend me, and I was wrongfully convicted. Because I'd been charged as an adult, I was given a 15 to life sentence, and I was sent to a men's maximum security prison. So let me share a few slides. I already have the slide up. This is my mugshot. I'm 16 years old there. I'm 17 years old in the picture that's being shown now. I'm in the courtroom. The jury has sent out a note to the judge saying that they've reached a verdict, but that result hasn't been publicized yet. This is me in the courtroom receiving the 15 to life sentence. I lost 7 appeals. I got turned down for parole. Ultimately, I was exonerated through further DNA testing, which identified the actual perpetrator. Here's a picture of me in the prison shortly after I arrived at Myra Correctional Facility. Here's a second picture. Here's when I was released. This is the first time I hugged my mother in a free environment. Okay, this is a picture when I opened my nonprofit organization, Jeffrey Deskovic Foundation for Justice. The first person we helped exonerate was William Lopez, who did 23 and a half years on a shotgun murder, which he didn't commit. Mr. Lopez passed away a year and a half after regaining his freedom. This is who did 8 years and 4 months on an arson case that actually was an electrical fire. Beyond being Jeffrey Deskovic Foundation for Justice, we're part of a larger coalition called It Could Happen to You, which the foundation is part of, and we do policy work, which I'm going to reference in a few minutes. So that slide that provides that some context. So here I'm getting an award for my role in helping to pass an independent oversight board for prosecutors. It's our Pennsylvania team. And people, real quick, in the slide, the tall gentleman with the baseball hat on and the tan clothes is Drew Whitley, who did 20 years prior to being exonerated through DNA evidence. In the red tie next to him, Terrence Lewis, who did 21 years and 5 months. Next to me, with his hair in the braids, Mark Whitaker, who did 21 years and 7 months. And the rest are people that are part of our coalition. Lady in the black, Karen Bookins, her husband John Bookins, has got about 30 years in prison so far, trying to get DNA testing, which the government will not allow. So that's litigating. And then next to her, with the glasses, Marianne Lucas, whose son is a client who was wrongfully convicted in a child molestation case, even though the DNA didn't match him. So wrapping up the photos, we're going to talk about today in terms of wrongful conviction prevention. It's about accuracy and justice, not anti-law enforcement. Definitely against rogue officers. It's not a few. It's a heck of a lot more than that. Nonetheless, it's not all of them in that profession. It's not against honest prosecutors. It's just prosecutors who don't respect federal or state constitutional rights, who violate ethics, and who otherwise infringe on fair trial. So I got my master's degree in John Jay College, which included a thesis on wrongful conviction cause and reform. And here is getting my law degree at Pace Pace Law School in 2019. So, changing gears and talking about the policy aspect of my presentation. So, how can policy changes prevent wrongful convictions? Well, in one aspect of it, one idea that's been talked about and is starting to come together is having a database of rogue police officers. So that's an example that can make a really big difference. Speaking of which, we've seen in New York City, just policy changes in terms on the DA offices and not relying on cases that have involved police officers who've gotten caught committing perjury and fabricating evidence and claiming to see things that haven't actually happened. In terms of potential for that, looking at that through the lens of policy changes, preventing and correcting wrongful convictions. Just to throw some stats at you, in Brooklyn, there's been 375 charges thrown out, okay, which is caused by 13 police officers. The breakdown of that further is 331 of those cases were misdemeanors, 47 of them were felonies. Queens, 60 cases were tossed. That was based primarily on 3 cops lying and other misconduct. In the Bronx, more than 500 cases have been tossed out. In Manhattan, 100 cases were tossed out, and prior to that, another 40. Some of the tactics engaged in by Manhattan police officers included not only test the lying, which is not telling the truth in court when under oath, but also claiming to witness things that they didn't actually see, for example, drug sales, and lying on paperwork. So that policy change illustrates how you can exonerate people, how a policy change, even on a voluntary level, can lead to exoneration. The police database, that certainly could prevent wrongful convictions on the front end. So if you're a defense attorney and there was a centralized depository of that information and you're handling a certain case, you can cross-check whether the officers involved in the case that you're defending or even prosecuting, have they been caught in misconduct in other cases. So that's a clear illustration of how just that policy change can lead to preventing wrongful conviction. In terms of legislation that the It Could Happen to You Coalition, which I'm part of, helped pass, and that policy leading to prevention and correction of wrongful convictions. Certainly the Commission on Prosecutor Conduct, which is an independent oversight board for prosecutors that can investigate allegations of prosecutorial misconduct. The hope there is that the Commission's existence will serve as a deterrent to prosecutors, give them something to be afraid of before they dare engage in misconduct. And so that policy change can certainly prevent wrongful convictions, keeping in mind that prosecutorial misconduct is a factor that runs through many of the wrongful conviction cases. We helped to pass discovery reform, so the same coalition gathered many different organizations and individual advocates, all of whom favored discovery reform, but they really couldn't agree on the details. And so that stymied the process, and so we were able to gather the groups together, have a set of principles, actually get everyone to buy in, and then we all moved as one. And we were able to help pass discovery reform. Discovery reform being sharing information by the prosecution and the defense. The way that it was previously under the New York rule, Rosario rule, the prosecutors would only have to turn over evidence and witness statements. Number one, only people that they were intending to call at a pretrial hearing and at a trial. So if they were not intending to call somebody, they didn't have to turn it over. And often there would be document dumping and evidence dumping on the eve of the hearing or a trial, which obviously prevents the defense from being able to conduct adequate investigation, put together their whole theory of the case ahead of time. There was a lot of pretrial litigation that went on. So the discovery reform makes it automatic now early in the process. So a lot of people who were innocent were pleading guilty without ever knowing what the evidence was against them. And the prosecutors would put what was referred to as a exploding offer on the table, where you can plead guilty today, but it's 2 to 4, but that's only for today. The offer's gone at the end of the day. And typically what would happen is defendants would ask their attorneys, well, do you think I should take the deal? And of course the defense attorney is going to say, I don't know. I don't know what the evidence is against you. I don't know what the viability of a defense is. I don't know if I can win the case for you. And often in a damage control, people would plead guilty. I mean, you might be facing 25 to life in a murder case, but the offer is 5 to 15 or 8 to 30 to 25. Significantly less time than if you lost a trial, but nonetheless a sizable portion of your life. So that was fundamentally unfair. And so the discovery change would prevent that. But another element of the discovery reform was that it created what's referred to as a continuing discovery obligation. So at any time, even after the case is finished, if there's exculpatory material, the prosecution has to turn it over. So that's another example of how policy changes can prevent wrongful conviction. With the passage of the DNA statute some years ago, which granted defendants the right to DNA testing, a lot of people have not been wrongfully convicted because that statute, giving the right to DNA testing, many people are being excluded by DNA on the front end of cases, and so that's an illustration of wrongful conviction prevention by way of policy changes. So I'm going to end by briefly discussing some pending legislation right now. So there's you should write these down and know about them and research, and more importantly, express interest in them being passed when it comes to your assembly people and your senators. We have the Challenging Wrongful Convictions Act, which is pending in the legislature right now. And so what that would do is this, first of all, defendants don't have a right to an attorney in a post-conviction proceeding. So an appeal is when you're raising issues of law that exist on a record already. A post-conviction motion, in contrast to that, says, I'm going to bring in facts and evidence that don't exist on the record right now, and I'm then going to make legal and factual arguments based on that new evidence. So defendants don't have a right to an attorney in a post-conviction procedure. So looking at my own case as an example, when my appeals were over, I had 11 years, and I spent 4 years additional in prison just writing letters looking for an attorney and an investigator to take my case, because once your appeals are over, the only way back into court would be if you can find some previously unknown evidence of innocence. And I wasn't going to personally find any evidence on my own, locked away in a prison cell doing a life sentence, hence the need to write letters. But why should it come down to writing letters and trying to get attorneys, investigators, and other professionals to take a case for free? It's really a governmental obligation. It should be built into the system, hence why that's an important element of the Challenging Wrongful Convictions Act. Another thing is that there's in the People versus Tiger case, it's bad case law that says that if a defendant has pled guilty, and which often goes together with having a terrible attorney on the front end, that let's say after that you get a good attorney, you get an investigator, and they find some new evidence that would support an actual innocence argument or newly discovered evidence argument. If you've pled guilty, you're not allowed to argue that anymore. That door is permanently closed. You would be limited to arguing that evidence shows that your attorney didn't do an adequate pre-trial investigation. So I have a case in Buffalo I'm co-counsel on, and my client Omar Clark is in that same situation. So we're jumping through contortions in the courtroom, and yeah, his lawyer was ineffective, but more to the point, he's innocent. But we can't argue that. So that's an illustration of that. And by the way, there's been it was a judge, I don't remember his name, but he estimated that 10% was a percentage of defendants pleading guilty to crimes that they didn't commit. So that's one piece of important legislation. As I mentioned earlier, false confessions have caused wrongful convictions in 25% of the DNA-proven wrongful convictions. So legislation is pending now that would result in improved police procedures, which would translate into less false confessions, which would translate into less wrongful convictions. So those pieces of legislation pending right now are the Youth Interrogation Act And that's a proposal that says, that recognizes that youth 16 to 17 years old do not understand their rights, and so prior to them being able to waive their rights and speak to a police officer without an attorney present and without having to speak to an adult, it's saying that they have to speak to an attorney first. Like, I remember when I was questioned, cops read me my rights countless times. I never understood them. I was 16 years old. And every time it got to the part where it said anything you say can and will be used against you in a court of law, my mind went to civil court. Court, what are you talking about? We're not going to court. So there's no way I could understand that. And so too, there's really no way that most people can understand that at 16 and 17. So the Youth Interrogation Act, that's how that would work. There's another bill that's referred to as a police deception bill, recognizing that police officers lying to suspects is inherently coercive, and so it would ban police from lying to suspects and claiming to have evidence that they don't have. One other measure that's being worked on now, there's not a bill yet introduced yet, but that would, there's a law in New York that mandates that police record interrogations, but unfortunately the law came out watered down, and they made exceptions for murder cases, sex offenses, and drug cases. And I'm saying that those are the cases where we need it the most. You know, that's what we needed. Or is it that a coerced false confession unrecorded would be okay in those limited situations? Well, I'm saying no situations is that okay. It would make it clear if somebody really was voluntarily waiving their rights, if they really did have guilty knowledge of a crime, or was information being given to them, were they being threatened, were they not being threatened. It would make everything clearer. And by the way, it would make for better evidence too, okay? And it would protect honest cops from false allegations of coercion. So it's really that this improved procedure would benefit both sides. So there's an effort to get rid of those exceptions. And with that, I'm going to call up noted civil rights lawyer Cory Morris, who's going to speak as a practitioner on how policy changes have created other tools for civil lawyering. So Cory, if you would come up, and thank you. You'll hear from me later on.
Okay. Thank you for having me. As Mr. Deskovic said, Cory Morris is my name. I was sitting in these chairs not so long ago. Jeffrey doesn't know I'm about to say this, but 15 years ago, I was sitting in a chair like one of you, hearing this young man come and tell me about his story, that horrific story. In one of the appeals, I remember the court said there was overwhelming evidence of guilt, not just regular guilt, overwhelming evidence of guilt. And it's horrific because I'd like to tell you things are better, but they're not. So again, I'm Cory Morris. I got my graduate degree in psychology. I taught for a number of years at Delphi University. I do this work. Even yesterday we had a very large civil filing, and it's interesting how things are construed and perceived. But so 15 years ago, I had the honor of hearing that story, that really terrible story, and I said to myself, you know, this is what I wanted to do. I wanted to make sure that, you know, things don't happen. So we right wrongs. They don't necessarily teach us out of a book. You know, what could I do as a psychology student? Anyone hear about that case, Brown versus Board? Anyone familiar with that case? Got a couple of hands. They changed the law. What was the law? Does anyone remember? By the way, ask questions. I know there's coffee, so I know all you are waiting. So I want to hear, you know. And I'm glad I know PowerPoint because I would like to leave this. I'd like to burn this into the wall here. Please participate. Brown versus Board of Education said, you know, separate but separate but unequal, right? We can't. That's what they came to sue for, right? Thurgood Marshall and a group of civil rights lawyers.
Separate but equal,
yes.
not unequal.
Separate but unequal. So Plessy, separate but equal. Plessy versus Ferguson. I'm sorry, as I'm being recorded here. It overturned Plessy versus Ferguson on a footnote. The footnote was a psychological study. W.B. Clark, the doll study. So you can all make a difference here. We have a case now. We're going to need an expert on historical use of weapons and the First Amendment. Where do we even find such a person? Well, they're born in classrooms like this, but they're not just born here. They foster an understanding that what you do can make a huge impact in somebody's life. I give it to Jeffrey Deskovic because not everyone gets out of jail and is able to do half of the things that this man has done. So, unfortunately, I'm here, we're going to talk about some of that and what we could do. So, as psychologists, you have enormous opportunity. That was one of the things that spawned the reform, among other things. Anyone ever hear the name Khalif Browder?
Yes.
Okay, and we know that name, right? Because unfortunately, what happened to him should happen to no one. Suffering through these indignations, speedy trial. Jeffrey said, terrible public defender. He had a bunch of terrible public defenders. And what did he do? What was so noble and so bold? He sought to go to trial. He sought to put the people to their proof. Time and time again, over 40 times in over 3 years, they didn't have that proof, but everyone says, oh, it's the discovery. No, that was a public defender, a lawyer. That was a prosecutor, a lawyer, and that was a judge that allowed that to happen. And that's the issue that we face here today. So some of the tools, some of what I do, and if you have questions, just ask. As a civil rights lawyer, I tell folks all the time, they say, why should I hire you? And unfortunately, we have to get money from clients. So my criminal defense clients, why should I hire you? I want a former prosecutor. I said, look, it's not all the same. The civil rights attorney, we do all the investigation. We do what's called freedom of information law. If there is a problem with a prosecutor, we don't just let it lie. We continue and we sue if need be. And that's what we do as civil rights attorneys. So one of the tools is the freedom of information law. And Jeffrey asked me to talk a little bit about that. So I do a lot of this litigation. Even now I have a lawsuit against Alvin Bragg, which we could talk about surely. So how do you make a database of rogue police officers, Jeffrey said? Freedom of information law. And what happened? Civil rights law section 58, which George Orwell is rolling in his grave right now. Civil rights law 58 protected police misconduct records. If you ask for their accolades, you get them all the time. And there's some really great police out there who do a great job. But you get the misconduct records now because of the repeal of Civil Rights Law 58. That happened 2 years ago. So where are the records? If I had a PowerPoint, you'd see the Institute for Access to Public Information. We sued the city of Middletown, which is being recorded, but I got a very odd response. We did a pro bono project on behalf of Muck Rock, so we send out litigation hold notices, because immediately we said, wow, the police are going to have the greatest retention policy. All the records are going to disappear. Because if I had misconduct records, and I wanted them gone, I'd have a retention policy that says we destroy our misconduct records after a certain amount of years. So we sent out litigation hold notices. Just so happens one attorney responded, Alex Smith, from the city of Middletown, and I said, boy, if anyone ever comes to me with a case against them, I'm going to take it, and we did. So all the misconduct records from the city of Middletown are now online. So yet, in Suffolk County, not from, grew up in Brooklyn, but now I live in Suffolk County, where the chief of police and the former DA went to federal prison for police misconduct. I can't get the misconduct records. Personal privacy issues, says the Suffolk County that just got hacked. Nassau County, New York Civil Liberties Union did us a favor and is appealing it, but we don't have good law. So why would a private attorney take such a case? There's an opportunity, it's evanescent, for attorney's fees. But if there's bad case law because another group comes and says, we're going to sue, they lose, and everyone says, well, look, we have this reasonable basis to believe that we can withhold misconduct records on the basis of personal privacy. And that's what we're dealing with right now. So we filed suit 9 months ago. We're waiting for decision. Ironically, Kirkman Ellis, I believe, just filed suit a few days ago. I hope both of us get a decision. I hope they're both good.
Which one is more difficult to work with, Nassau or Suffolk?
Oh, that's like, if there was a race and you had 60-something counties, Nassau and Suffolk would be neck and neck. There was a FOIL request to get the calendar of who was it, Adams. So de Blasio laid out his calendar. This is what I do with public dollars. Adams, this is what I do with public dollars. Not as much as de Blasio, arguably. No politics here, but not as much, arguably. The police chief of the 12th largest police station in the entire world, I believe, right? The 12th largest, doesn't want to give us anything. I have to sue him. After I sue him, I have to explain to the judge, they should release the records. Denied. Then I had to re-argue, and we're still on appeal. And these cases go on forever. So where was the police chief of Nassau County when all those civil rights reforms were supposed to happen pursuant to law and because of the death of George Floyd? I don't know. And the problem is Nassau County is very ingrained. I had to sue Nassau County DA, Madeline Singas, before he became the chief judge. And this is in line with the discovery. I know our time is limited. In Nassau County, in their infinite wisdom, they decided to implement what's called Justware. It's a third-party software. My client, an attorney, said, "What? There's no terms and conditions. So agree to the terms and conditions." Would you believe the entire county, Nassau County, agreed to terms and conditions that were non-existent? They just didn't exist. And we said, how do we know this is safe? Suffolk County being hacked, the New York City Law Department getting hacked. How do we know that our client data isn't being transmitted or tracked? And for sometimes it's good, we want to track, data, but I'm not going to be part of that if I'm representing somebody, right? It's a bad idea. And the last thing is, how do I know it's secure? Cybersecurity, all these cyber insurance, you hear about it all the time, and now, New York State requires attorneys to be competent with this. So he sued the DA, we settled the case, and then she became one of the chief judges on the Court of Appeals in our state. That's one of the highest courts. One of the courts that, one of the appellate courts that Jeffrey had to go through, unfortunately, that said there was overwhelming evidence of guilt. How could that be? Well, look at how they got there. They were part of that system, and this is how they moved up. So we represented Muckrock on a pro bono basis. We represented Mr. Pudge, an attorney. We got the Middletown misconduct records, but unfortunately the Suffolk County records are still outstanding. New York State Police, we're in the third department. Right? We're in the appellate courts. New York State Attorney General, the people's attorney, is defending the New York State Police Department that can't figure out. They've got a whole team of attorneys in New York statewide. They can't figure out what misconduct records we're requesting. If we narrow the request to 3 counties, evidently that's not good enough either. And the judge says that's okay. So years after this law was repealed, and I say that with air quotes, repealed, I still can't get the misconduct records. I've got to either scream open sesame or abracadabra, X marks the spot. I don't know, they don't teach in law school, so I have to continue to push this bill. But in reality, and I'll give you a quick case, Jeffrey said it very well. Thank God, eventually someone took this case and got him out, because really this is one of the greatest advocates we have here, because not only did it happen to him, but it happened to others. Others that just don't have the wherewithal, even if they didn't go through that horrific process, to do this. People versus Hewlett is a case that talks about FOIL. In 7 pages from the highest court, Court of Appeals, it talks about the evidence. What was withheld? Well, there was a video. Well, the prosecutor gets up and says, don't you think if there was a video you would have saw it? Don't you think if there was a video with somebody else you would have saw it? The man is convicted. It goes through the motions. Someone at the Bronx Defenders, boy, I love them. Whoever this attorney is, I love to meet. Makes a FOIL request, Freedom of Information Law. Everyone could have fun with FOIL. Ages 5 to 105, you can make a FOIL request. Ask for anything. They could just deny it, but they have to respond. Bronx Offenders makes a FOIL request. Can we get all the video? Would you know it? An honest prosecutor answers, gives them the video. What does it show? All the way up to the Court of Appeals. It says, oh, that's insignificant. Until it gets to the Court of Appeals. It shows another person over the victim with the gun. Case reversed. Little footnote, FOIL. So we could do that before the conviction. 2 minutes. 4 on this one. All right, so quickly, look, the courts are flawed. We have a system, unfortunately, that relies on funding. We have one person doing both funding, right? The DA and the defense attorneys are funded out of the same place. But the problem that we have, unique in our criminal justice system, that we don't have in other systems, is what's called immunity, right? They've changed a lot of laws recently in the Supreme Court, talking all about history. There's no such thing as immunity in this regard for police and for prosecutors to the extent we have. Police are allowed to lie. Jeffrey hinted at that. It's legal. They are allowed to lie by making it legal. They've actually told the police, we want you to get convictions, not justice, convictions by lying. And that's what you get in wrongful convictions. Today I sent an article out, wrongful conviction, $12 million verdict. It wasn't against the DA, it was against a public defender. So we have duties as attorneys. I'll say one quick story, and then I know my time is short. Right here in Manhattan, we have a case. I represent Lambros Lambrou, big personal injury attorney. You look him up, very nice office, 3-story waterfall, the whole nine. He's in litigation. He's asking for records. His client was unfortunately killed by a New York City employee. The people of the state of New York, that's what they call themselves, County of Manhattan. they pursue a litigation. They get a misdemeanor conviction. It's an open conviction. Where are the records? Mr. Lambert, we need another month. We need another month. We need another month. This is this attorney who's been practicing law almost as long as I've been alive. We need more time. He goes, no more. Cory, sue. I sue. 2 days later, 500 pages. By the end of the week, 7 videos. What's it show? Boy, you know, this enormous truck careens and kills this poor pedestrian walking through. And what's it say when a judge says, you know, they gave you the records, thank you for coming, you know, have a nice day. No, there's no accountability. And although I can't seek jail time under the criminal procedure law under 42 United States Code 1983, a civil rights lawsuit, I can seek it under the public records. So to tie these things together, public records. Here I had to make law to get body camera footage, and then it cost the city a lot of money. This other case hopefully will too, so I could get paid, because unfortunately this is how we do it. But in reality, FOIL, sunshine law down in Florida, you don't give it over, it's a misdemeanor or a felony. I'm asking to put the prosecutor in jail for 15 days. That's what we have in New York, and no one will enforce the law. And that's the scariest part about this. Bring it full circle, so People versus Hewlett, you can get the evidence before. This FOIL, this is the only way we can get the misconduct records, but we need courts and people to enforce it. And the last thing is, in terms of discovery laws, it's the accountability element that's missing. In other states, like for instance, I'm licensed in Florida, it occurs in Florida, we're missing it here, but we're missing it here because we need you. And please support this wonderful foundation. Continue to be that voice, because it's just one person. You take one step and you're making a difference already. Keep on that path. Stay after if anyone has questions. Please, our next speaker.
Hi everyone, good afternoon. My name is Sorochinski. I'm a psychologist by training. I did my PhD at John Jay, and I am a professor at St. John's University right now.
Excuse me, go behind for the audience.
No, I don't like podiums. I'm here to talk to you a little bit about how research and how what we do on the back end, the academe, how does that feed into and translate into actual change within the system. Something that really I care deeply about, primarily because I think, you know, as somebody who's been in academia for pretty much my whole life, I never did anything else besides moving through steps in different stages in academia. I like to think that what we're doing is useful and has a true impact on the real world, and makes the change. You know, all the research that we're doing is not for the tables, it's not for just us and our intellectual masturbation, if you excuse my parallel, but it's an actual impact that we can make in the system, okay? So I did a little research, because that's what I do, in preparation for this talk, and I found, well, obviously the first study that has been published that relates to wrongful convictions was a little bit over 100 years ago. So in 1913, the first study focusing on eyewitness identification and how that works into wrongful convictions was published, and since then over 6,000 articles, if you search on PsycInfo or any other big academic search, you will find there's over 6,000 articles, peer-reviewed academic articles on different aspects of wrongful convictions, right? Within that, we have over 2,500 articles that focus on eyewitness misidentification. This is not something that has been touched on today, but you probably know plays a big role in wrongful convictions in terms of misidentifying the person, and kind of how that actually, Jeffrey mentioned 25% of exonerees have falsely confessed. I believe about 60% include an eyewitness misidentification. So it's a big, big issue, right? So this may or may not seem as a lot of research if you compare it to some other fields in psychology, like, you know, if you search depression, for example, you will find there are upwards of 30,000 articles. So everything is obviously in context. Other areas that researchers are focusing on in terms of psychology and how that helps or informs wrongful convictions, looking at jury decision making, looking at how wrongful conviction, how exonerees actually fare post-exoneration. There's a very small research area in that aspect. This is something that we should really work on a lot more. So what, right? So what? You say, well, do that research. What does that mean? There's been some change that may or may not seem like substantial again, and we are, I would argue, need a lot more of that happening, and a lot more on a massive basis. But lineup procedures in the police investigations have changed substantially because of research, right? We have APA that has put in briefs and amicus briefs to courts that have changed cases, and case law that has been established since. Interrogation, anybody knows here about the Reed technique? You guys have heard? No, nobody else? Just John, okay, John Jay delivers. But so the Reed technique, let me just quickly focus on that, is since Jeffrey also started with how he ended up in his false confession. Basically, textbook Reed technique has been used in this case as in many others, and this is something that has been established in 1950s by a police officer, investigator, John Reed. He decided to come up with an interrogation technique that will be not using a physical coercion, so no more hitting people on the tables, and instead using psychological techniques. So it was designed to be non-torturing. I guess it's a step upwards from actually physically beating people up in the interrogation room. But what it did was basically come up with a bunch of manipulation tactics, psychological coercion that works just as well as physical in making people confess to things that they have not done. And that technique has been pretty much standard in the US across the board, and still is, unfortunately. This is what people are taught. So even though we're talking about police officers, police misconduct and police officers doing the wrong things, a lot of times they're not doing it out of malicious intent, but rather this is what they've been taught. The manual actually says this is a technique to get a confession. Again, not a technique to get the truth. It's a technique to get a confession, right? In the UK, they are way, way more advanced than us, unfortunately, in terms of integrating evidence-based practices. And all the way back in 1986, they already decided and mandated across the country that all interrogations have to be videotaped, right? This has still to happen in the US. We're kind of gradually getting that done with, again, a lot of research showing that it's important, showing that the whole interrogation has to be videotaped, not just the confession part, which obviously makes it seem very biased. But in the UK, they've also developed an evidence-based interviewing. They don't call it interrogations in the UK, actually. They call it interviewing practice, and it's called peace technique. I don't have it on here, but it's basically psychology-based, rapport-building technique that teaches people how to interview without forcing them, without tricking them, without making them fall into your manipulations, right? I really want to highlight a new development in the worldwide practice, right? The Mendez principles, you should really look into that. I don't have time to get into that a lot, but this has been recently put up to the UN General Assembly as a range of principles on how to do science-based, ethical interviewing, right? In a variety of contexts, including police as well as terrorism, as well as international interrogations, right? So there's a lot of work that academics are doing that actually makes its way into policy, and I do want to, I don't have time to talk about my teaching class, but the other way that academia is making, I do want to end on this, you are the future of this field and making that change actually happen, because what really is important is this cycle of asking questions or getting information, asking questions from the criminal justice practice, doing research, and then feeding that back into teaching. And so the new generation of practitioners, the new generation of criminal justice administrators and legal professionals and lawyers and DAs coming in with that knowledge, having heard cases like Jeffrey's, you can't unknow this right now, right? You have this information, you will be getting into your careers already with the understanding that things need to be done differently in order to avoid things like this happening. So I'm going to pull Jeffrey back.
And to quickly just add, to further Marina's point about research, as somebody who's doing policy work, with the research furnish statistics that I can reference when we're talking with elected officials. And social science is what validates improved techniques on identification procedure, even in terms of the best practice with regards to videotaping interrogations, completely from beginning to end, the camera on both the interrogator as well as the person being interrogated. That's all backed by social science and research. So I'm going to have one more person come up for like 4 minutes. One of my guests, Anthony Dalsey, is going to come up and tell you a really quick snippet about his story, the group he's working with, and the policy change that they're seeking to implement, which also would prevent wrongful convictions. Please come here so the audience at home can see you.
Thank you. Good afternoon. My name is Anthony Dolce, and I'm the director and co-founder of the Stop False Police Reporting Group and the co-author of the Stop False Police Reporting Initiative. It is so important that we have this conversation every single day about false reporting, because every day another innocent person is wrongfully arrested or wrongfully incarcerated or wrongfully deported or wrongfully committed to a mental psychiatric ward where they don't belong. And in some cases, it leads to death by police officers. I myself was wrongfully placed in handcuffs 10 times during 2018 and 2019 after my former landlord instructed their employees to call the police on my family. Their false police reporting caused me to be placed in jail and a psychiatric facility for 9 days where I did not belong. I was subjected to medicines for mental disorders that I did not suffer from, and eventually I was released. Their false police reporting also caused my front door to be broken down twice by the police department and the fire department based on false allegations by my landlord. And these experiences that my family and I suffered inspired me to start the Stop False Police Reporting Group, an initiative. Our group meets every Sunday to give support to individuals like Jeffrey and myself who have been impacted by false reporting by law enforcement and civilians. It is a space where people can talk about their feelings and talk about what they suffered, because not everybody wants to hear what someone else has gone through. So the initiative in October will be 2 years that I've been working on the Stop False Police Reporting initiative. In this initiative, we have 6 provisions to protect people from false reporting by law enforcement and civilian. Provision number 1 will make it a crime to both civilians and police officers. Provision number 2 will make it a felony for both civilians and law enforcement officers who file false reports against a protected class of person. Provision number 3 in our initiative will allow defendants to have the right to know why their case is dismissed. And this is really important because in the state of New York, we have over 50,000 cases that are dismissed every year. And when my criminal case got dismissed, all I got was a little piece of paper saying my case was over. But it left me with no answers to what led to that decision. So this provision will create more transparency, and people who are maintaining their innocence, the prosecutor should seek the truth on both sides, not just building the case against an innocent person, but they should think maybe the defendant is actually innocent of this crime. Provision number 4 deals with police accountability, both pre and post conviction. Number 5 deals with immigration. And provision number 6, data management. We heard Jeffrey talk about that a little bit earlier. This is so important. So when a police officer or a civilian is convicted of false police reporting, their name is going to go on this list. And when we pass into law these 6 provisions and it becomes a felony, it will be permanently on their record. We have to weed out the bad apple police officers and civilians who are using the criminal justice system to destroy innocent people's lives. And one of the biggest problems with false reporting is the lack of prosecuting the perpetrators of these crimes. So more and more people will continue to be victimized by this crime until we have more accountability. That's why it's so important we get the right prosecutors and judges to tackle this issue that we're facing in our community. And I will finish by saying that if the law allows us to incarcerate innocent individuals into our system, surely we can prosecute the law enforcement officers and civilians who put them there. My name is Anthony Dolce. We're the Stop False Police Reporting Group. You can find us on Facebook, Stop False Police Reporting, and on change.org, Stop False Police Reporting. Thank you.
So we're gonna open for Q&A, and you can ask any of us anything you want on today's material, or even some things related to that we maybe weren't explicitly spoken on. We usually need one person to give a question, and Dr. Takushian.
Your timing is impeccable for the discussion. The first question, many times students want to be involved in social justice issues. Is there any way they could perhaps file for internships, or you might
Yes.
invite them to your foundation to see what you're doing?
Yeah, absolutely. We have the foundation can offer internships, and some of it's remote, some of it's in person. The foundation's director of special projects is in the back of the room. Gina Antonelli is right there, so she manages a lot. So we can do that, and we're also going to make an announcement on we'll have an open house at the foundation headquarters. I think we're looking at the 8th of October tentatively, but I will give you the firm date and you'll share it. It is competitive. We can't take everyone. There's going to be 2, maybe 3 positions at max. Cory, I don't know if in the course of your work, if you want to entertain an intern on some of the research aspects.
I'll leave some cards. I'll put some over there. I tried to get Carrie London here, who is the civil rights managing partner of Shulman Hill and a bunch of other folks. I know he's accepting folks. Hopefully he'll give me that information sooner than later. I'll be glad to talk offline. It's a difficult path, fraught with peril. Nobody sort of likes to do this, but it's really important work. So I joke around and say if you're independently wealthy, or if you really have a burning desire to do this and fight the system, give me a call, lead me in the right direction. Start with a letter to a law student interested in social justice by Bill Quigley. That's what I suggest.
Well, I know that one of the challenges on the false police reporting group is, Anthony needs more labor, more people to help out. So I think there's some internship opportunities there as
Yes,
well.
we're also looking for volunteers to join us every Sunday. We go out on the street and we pass out flyers and we raise more awareness about false reporting by law enforcement and civilians. It's so important that we get this word out to everyone out there.
Manhattan?
Yes, here in Manhattan, yes. Yes.
All right, so Marina, in the course of whenever you take on your next research project, as if you don't have enough out there already, might you see your way clear to take applications and consider taking a research assistant? I know you got your obligations with St. John's, but
Yeah.
maybe we can give one position to somebody else over here.
That is a bit tricky with the
Okay.
universities, but if I'm happy to
If we can navigate the
advise and
bureaucratic.
support, absolutely.
Okay. Any other questions? We usually need one student to ask the first question, and it goes from there. It's really easy.
Well, I'm not a student, but I would like to ask a question.
That's
about
recognized. You're done. Go ahead.
About this, the discretion to prosecute, and what goes on in that, when that decision is made. I know it seems like the prosecutor makes a decision himself, but shouldn't there be somebody there to help him with that discretion to make sure that it's objectively a good case?
I mean, that normally would happen by like a bureau chief or the bureau chief's assistant. It doesn't usually go all the way up to the DA. I mean, it could, but it usually doesn't. But I think you're more like somebody objective, and I don't see how that would necessarily work within the office. But I do agree that when charges are dropped, I know this is not really exactly what you're saying. There should be a reason for that, but people not being prosecuted sometimes is an issue also. I really don't have an answer for that. And by the way, Henry is fighting a wrongful conviction case as well. How long did you maybe just stand and turn real fast?
Well, my name is Henry Smith. I'm fighting a wrongful conviction myself. I did 25 years for a crime I knew nothing about. Just walking down the street, and I fit, I guess, the situation, and it's a long story, but we hope to be making a type of show where we're showing these wrongly accused individuals, and you can see the story and see what part they played, what part the police played, what's going on here. And so hopefully, we will be more enlightened about these criminal justice issues.
By the way, we were wrongfully incarcerated together at the same
Oh yeah,
time.
Jeffrey's my hero. I was on the inside with this guy. And to go through that process with sexual charges and rape and murder, you know what I'm saying? My heart always went out for him. We never really spoke that much. I worked in the library. I'm saying for like 10, 15 years. Like that was my home. And Jeffrey would come there with a group of guys, a lot of exonerees and that's out. And we would try to figure out what's going on with the system. Why they're producing all these wrongful convictions. And I salute Jeffrey. He's been through so much, man. It's God sent. He's a God sent. Yeah.
Thank you. Questions?
I'll just say that discretion, prosecutors need to have discretion, but they also need to have deterrence. If I make a bad decision, I'm accountable. And there's just I hate to say it, but there's a complete lack of accountability for prosecutors. There is no accountability. And if you sue a prosecutor, and I've done it, the only thing that happens is the taxpayers pay twice. He gets incarcerated, the guy who did it is still out. Anyone ever arrested, anyone ever reprimanded, anyone in your case, anything ever happened to anyone?
None of the people involved in my wrongful conviction, nothing ever happened to them. The actual perpetrator was identified and convicted, but in terms of on the law enforcement side, no, nothing ever happened to them. The most that happened, there was a couple of indirect fallout from it. The medical examiner, when I filed this civil suit naming him in the county, he suddenly retired. And the prosecutor who prosecuted me 2 weeks before I came out, he suddenly retired and ran to Florida. So it seems clear that he was tipped off. But those are all indirects. Nobody ever paid for that, criminally. And while I brought a suit, it was ultimately the municipalities that those parties worked for that paid And actually, if you do bring the case against the prosecutor, and I did it, it was dismissed under the immunity which you talked about earlier. The only way you could get around that right now, and I guess this is where we need definitely another policy change, is under the doctrine of prosecutorial immunity. Any misconduct the prosecutor does, no matter how egregious, if it happens after an arrest, then they have complete immunity for that. The only way around that would be if they insert themselves into the investigatory part of the case, then they have qualified immunity rather than.
So just so people understand, that means they could withhold evidence,
Yes.
they could hold the confession, they could hold the keys, basically show somebody's innocence and prosecute someone, whether they have the burning desire to do so or whether the most innocent, so that's unfortunately where we're
Okay, in
at.
the back, then I'm gonna come back to Henry again. and then go around.
Related to that, what about like Brady violations and stuff like?
Which Brady? Martha Brady?
No,
Brady,
no,
Brady,
there's
Brady.
a law- No, but there's a law of Brady. So anything that's exculpatory has to be turned over. That's been a law even before discovery changes. And the problem with that is that there's no criminal penalties for it. You can't sue them individually.
No penalty at all.
No, and even in terms of getting the conviction overturned, while that's a legal argument to do it, at the same time, that's not, getting the court to recognize that a Brady violation has happened does not equate into an automatic reversal. That's subject to what's called harmless error analysis. So they try to look backwards on the case and determine if you would have been found guilty anyway, because if so, why are we gonna waste all this time and money and effort at doing it? So that's a significant problem.
And just to add insult to injury, and unfortunately, my colleague, now I'm so proud to say is my colleague, can tell you this, the court uses inflammatory language, like overwhelming evidence of guilt. One of our chief judge, the Supreme Court of the United States, he's never been stopped in a car before. He's never suffered a car stop, if anyone drives and ever been pulled over. Just think about that, when we talk about judges making those determinations and not juries making those determinations.
By the way, once misconduct has happened in the case, it affects the lens from which the entire trajectory of the case. I don't believe there's any way of going backwards and determining what would have happened. And more to the point, someone has suffered from a Brady violation, they've had their right to a fair trial infringed on, and the only way of restoring that is to reverse a conviction. So I saw a student hand in the back, right here.
Oh yeah, I was gonna ask about police being mandated to record interrogations,
Yeah.
and would that also seep into recording, like obtaining evidence? Because what it sounds like from your case is that they.
That would fall under discovery reform, and in my case in particular, they did not record. There was no audio confession, there was no video, no signed confession, just their word for it. That's what allowed them to leave the threat and false promise out of their statement. Now in the 6 weeks run up to that, they would record, but they kept starting and stopping the tape repeatedly. So the obvious question, what are you hiding? What went on during that unrecorded time period? Henry, statement or a comment? Statement or question?
Real quick.
Yeah, sure.
Another way to expose or bring some type of relief to people is by exposing these stories.
Yes,
And,
yes it is.
Right, and we are hoping to create the show where we could expose these stories. Like you see a lot of CSI, you see criminal law, you see all these different, they're trying to give us information about the system. We need to expose these these wrongful convictions and what really happened in story form, so people can pick up.
Right, and a lot of times, an injustice, an exoneration bubbling to the surface and happening often opens the door for other people who are affected by the same people. Like, when I was talking about the database and the dirty cops and all these scores of cases, I mean, most, if not all of them, would not have gotten free had somebody that misconduct not came to the surface in the course of a case. Doug has a question or statement?
Yeah, quick one, Cory.
I'm sorry, you wanted to say?
Obviously,
I'm sorry, she wanted to say something? I'm sorry.
No, I
We'll
just
come
wanted
back to you in a
to
second.
bring to your attention, and Jeffrey mentioned about the true perpetrator in his case getting eventually convicted. He got convicted after he committed another rape and murder. And that is the case for a lot of wrongful convictions where somebody gets wrongfully convicted so you have the victim that originally died, you have the victimized individual who gets wrongfully convicted and his entire family obviously becoming victims of that situation. But then you also have the true perpetrator who remains out and has the opportunity to commit more crimes. We've recently finished a study on this, which showed that in serial cases where a wrongful conviction is present, there are twice as many, on average, twice as many victims as a series where the true perpetrator gets immediately caught. So just to kind of contextualize, it's an issue that has an irradiating, exponentially increasing number of victims with every such conviction.
Doug?
Yeah, this is kind of off center, but you see on YouTube all the time these people being pulled over and not wanting to give ID or whatever. Cory, what would you be your feedback for something like that?
Argue in a court, not to the cop. Don't do that.
Deny ID and go along with that?
My colleagues, they say, Cory, what do I do when they use the joke. Somebody said, what do I do if I get pulled over? And for instance, Long Beach is notorious for drinking drunk. And one of my colleagues, flew off the handle. He said, run! You got a better chance if you could sleep it off than you just deal with the escape charge. No, they have these little cameras, front and back. Keep them in your cars if you drive. Cooperate with the police.
So get an ID.
Yeah, you give them your ID. You might want to keep the window that high. I would always tell you to cooperate with the police. Argue in a courtroom, not in a cop car. Tell them where your hands are. I can't tell you how many people decide to fumble around. It's the most dangerous situation as a cop coming to a car. He has no idea what is going on. Do not give them an opportunity to do something. And to their credit, that is the most dangerous situation. They have no idea. I tell folks cooperate with the police. Unfortunately, we're talking about bad police, but you got to remember, if we don't get rid of these bad police, that's the person who's got that officer's back in that dangerous situation. He can't, or she can't turn that person in. It's up to someone like me or the folks up here to get rid of that poison. It's not a bad apple, it's poison in the well. Because if we allow that to happen, more wrongful convictions, more terrible situations. So we have to extract the poison to allow the good cops to do their job. Otherwise, they can't turn in that person. It's not a thin blue line. It's death if they,
I just want to add one thing.
Your meetings are free?
Oh,
No, in the back.
Yes, on Sunday.
On Sunday, what time Sunday and where?
From 6 p.m., 8 p.m. You can be anywhere and call in to speak with me and other people who have been impacted by false reporting.
So as of right now, you don't have a location, it all depends, or do you have a location next meeting is at?
I have an ID for Zoom that I can give you and you can call in.
Okay.
Yes.
In terms of cooperating with the police.
It's virtual meeting.
In terms of cooperating with the police in the stop, and I agree with what Cory says, but remember, he's talking about safety protocols.
Yeah.
On a different level, but pertaining to the same subject, right? You should never agree to allow the police to search your car.
Yeah.
Because if they're gonna plant evidence, that's the time to do it. So you would verbally say, I am not consenting to your search. If you're going to search my car anyway, you may do so, but it's over my objection, it's against my will. And then let them do what they're gonna do, but never verbally agree, because that's just like people thinking that you can waive your rights and speak to the police without an attorney, because what's gonna happen, because you're innocent, nothing's gonna happen. Well, quite a bit. Quite a bit could happen, same thing on the search.
So New York, you have the indelible right to counsel once you say so. If you don't have an attorney, take one of these cards, literally hand the card. Every now and then the attorney couples it up, take two, give him another one. Make sure you have it on camera. Say it real loud too. I need my attorney. I'm willing to cooperate, but I need my attorney here if you're detained.
And don't let them talk you out of the attorney. What do you need an attorney for? I want an attorney.
Especially if you're innocent.
Yeah,
especially if you're innocent. Any other questions, comments, statements from the crowd? Anybody?
Thank you. One more thing about body camera footage. We sued. We got body camera footage. I wish Carrie London was here because it was his case. But we sued. We got the body camera footage. We had to sue the police to get the footage. It cost the county, cost New York County a lot of money. What did we get? We got a video where the action already started, and it wasn't flattering for our client. They withheld the video based on an active investigation, a use of force investigation. I said, how could that be? Our client's dead. One of the cops shot the other cop.
All right, well, thanks for listening to us, and that's today's event.
You really do a great job.
He runs a tight ship.
Fordham is interested in social justice issues, and it doesn't get more than this. We thank you, all the speakers. I'll be presenting them with a certificate on behalf of Fordham University for the work they do and sharing it with us. And if you're not in this, people in the law and psychology class will be receiving the emails of the speakers. If you're not there, you can just email me and I'll include you in the list probably on Monday morning.
I put some cards there, some cards here. Email me if you get pulled over. Yeah, please assert your right to counsel. You have to verbalize your right to remain silent, which is crazy, but yeah, you have to say it.
We'll be lingering here in the hallway. If you want to speak with us, please feel free to do so and meet the
I could
speakers.
have the sign-up sheet, and also if anybody wants the applications for NISBA, the State Association as a student, I have some here for you. Thank you.
That was great, Cory. Thank you. Thank you.
I'm going to put cards here for anyone who's interested in contacting me.
Photos of us?
Sure.
Thank you so much, Professor. Thank you so much.
Casey's diet show, the video should be online. It's a terrible